You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 83, Interpreting and Defining Words in a Patent. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call 424-281-0162. I've talked before about claims in a patent. The claims are what you are saying your invention is. For example, you can say that you claim a machine having parts A, B, and C, and then you go on to define what A, B, and C are. For the avocado 3-in-1 splitter, pitter, and slicer I've talked about before, those parts would be the splitting blade part that splits the avocado into two halves, the part that's able to take out the pit, and the multi-blade loop. So for someone to infringe, they have to have the product has to have all three of those things. Now, I'm really simplifying the invention here, but I'm just trying to remind you of what the claims are and why they're so important. Now, in this episode, I'm going to talk about how words are defined and why it's so important to know what words mean in your patent and how they'll be interpreted. Let's say in your claims, you said that part A has a blade. Someone came around and designed something very similar to your avocado 3-in-1 device, but instead of what we would consider a blade for the splitting blade part, someone decided to use a very dull, thicker, flat edge piece instead of a blade. Now, it might not work as well as a blade, but the reason they're doing it is that they're trying to get around infringing the patent that requires a blade. So if you're the owner of a patent of the 3-in-1 slicer and you sue them for patent infringement, their response is going to be that you required a blade. And clearly what I have does not have a sharp edge. It's just a long piece of plastic with a dull, kind of thick edge. So it's not a blade, and therefore I'm not infringing your patent. So how do we determine whether they're infringing? Well, it all depends on how a judge will define the word blade. And you can see that there could be a variety of approaches. One approach would be to open up a dictionary and look for the word blade and see if that potentially infringing device has what the dictionary calls a blade. Now, another approach might be to look how the patent application or the patent defines the word blade. Did the patent say that it had to have a sharp edge, or did it say that a blade is any long member capable of piercing and splitting an avocado into two? Or maybe it gave dimensions of what the blade is. You can see maybe a different approach where we would get expert witnesses in the blade industry at court to tell the judge or the jury what a blade is for people who are experts in the field. And you might get conflicting answers on how to define a word. So how do we approach this? Now, in the end, the goal is to find out what the word means to a person having ordinary skill in the art. But that's not entirely helpful because how are we supposed to actually figure that out? And the answer is that there's a hierarchy of sources to look to figure out what that is. And this was spelled out in a case called Phillips v. AWH in 2005. And it was about the term steel baffles, which should be how it's defined and whether baffles could be angled or whether they could be 90 degrees. Now, for our purposes, it's not important the details of that particular word in that case, but it was in this case that the court told us how we should determine how words are defined. The first sources that you look at are what are called intrinsic sources. This means that are things that are inside of the application itself. And you're supposed to find the ordinary meaning of words in the context of the patent documents. You don't go to experts or outside dictionaries first. Now, what this means is that if the inventor defined terms in the patent, that's the first thing that you look to. If the inventor in the patent said a blade is defined as a long member with an extremely sharp edge, then that's how it's defined. If the inventor said that a blade is defined as a long member with either a sharp edge or could have a dull flat edge that is shaped and sized to split an avocado, then that's how it's defined. Now, you can't make a definition that black is defined as white and white is defined as black because those are just opposites, and it's just not something you're allowed to do. But you can have a lot of latitude in how you're allowed to define terms yourself. They say that the inventor can be his own lexicographer, meaning that the dictionary that is used is actually in your patent application. Now, the next source that's intrinsic are things that aren't in the application itself, but are part of the application process. So if there was some back and forth discussion with the patent examiner when you first got your patent, and you told the examiner how a certain word should be defined in order to get your patent, that's something that can be useful in determining the definition of a word. But this information shouldn't be relied upon as much as the words in the context in the patent application itself. After you look at intrinsic sources for meanings of words, then you can go to extrinsic sources. These might include scholarly journals, expert testimony, or dictionaries, but the courts are only supposed to go to these secondary sources if it's still unclear what the meaning of a word is from the intrinsic sources. What happens is that if you sue someone and the parties are fighting about the meanings of certain words, there's a preliminary step before the trial begins, and that's called a Markman Hearing. And it's just a hearing for the judge to decide what the meanings, the definitions of words are. Once the meanings have been decided, then you can go on to the next step of the actual trial. So some advice that I have is that try to be clear in your application what words mean and define the words in the way that you want them defined, even if it's a little bit more or a little bit less than perhaps what's considered the ordinary meaning. Now, sometimes you want to be ambiguous in terms because you want to be able to catch as many people as you can for infringing your patent, but just know that there could be a fight later on if words can be defined in different ways. It's just something to think about and strategize about when writing your patent application. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamantpatentlaw.com or call me at 424-281-0162. And until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamant. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamant at patentingforinventors.com. That's patentingforinventors.com. Or call Diamant Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.